Thank you. We're finishing section 13, and what you've got are a couple of handouts related to some of the things we talked about over the last few weeks. One of them just shows you, and I saw this downstairs and thought you might want to take a look at sort of the notion of how impairment of earning capacities would be calculated, and I thought that was a reasonable description of in looking at it. So I thought you might want to see that in print. And the other is this article from April 3rd, 2012, which came from USA Today earlier than that, slightly earlier than that. And this is the issue we talked about with respect to the ability of American parents to be able to be able to, or in this case, as you see, not be able to obtain passports for their children who are born abroad. In this case, because they were assisted with the birth of those twins by reproductive technology in Israel. And since the eggs did not, well, the egg did not come from the mother, who was the American citizen, but who physically gave birth to these children as well, those twins are not considered Americans for the purposes of being able to obtain a passport and to be citizens here. I think it's kind of an interesting article. It's probably just yet another example where at least the law in part hasn't caught up with the technology involved. But it seems to have some pretty harsh results simply because of the source of the genetic material is not what it would have been 20, 30 years ago. Yep.
I just missed the two handouts.
Oh, okay, sure. I think it's an interesting article. I know some of you guys, I guess, talked about it in ethics as well. But it certainly raises a number of different issues on a number of different fronts, so you might want to take a look at it. But we're in the middle of nuisance and trespass and problems with respect to how we resolve issues that deal with people's homes and the like. And I thought these cases that we've got are pretty good examples of it. Of some of the creative solutions that equity looks at as well when they're trying to fashion relief on behalf of someone. So this is a lot. This is a lot of cement dust, and obviously that affects both their property, potentially their health. It makes their living there unpleasant, but my guess is we'd also find that there are potentially harmful side effects if we look that far, getting into your lungs and the like. But what they're really complaining about is that this is not a pleasant experience for them, and it does adversely affect their use and enjoyment of their property. Now, the first case, the Boomer case, talks a little bit about whether the nuisance is permanent or whether the nuisance is temporary. And if you look at it, what the difference, at least in the back end of this, will be that if it's permanent and unabatable, then a single recovery can be had for potentially the damage past and future, but that's only going to be one recovery, or where the loss would be small compared to the cost of removal. And in this case, we do, the case makes reference to some significant economic disparity between the commercial and social value of this cement plant. And these people have decided that they don't really care what the cost is. but they're looking to shut it down. Does the court have the ability, should they choose, even though there is significant economic disparity, to shut down the operation of the plant if it is in fact a nuisance, as the plaintiffs allege? Go ahead.
I would say yes, they have the authority to do so, but I mean, obviously they will do a cost-benefit analysis. I mean, depending upon who's employed in the community by that cement factory, the amount of revenue it creates for the community versus the pain that single, or the suffering that single family is going through. So I feel as though that if it was, you know, that much, if it was that significant, they possibly could, but in an effect like that, such as this case, they wouldn't, and not just offer permanent damages to supplement the family's suffering.
But permanent damages, in essence, lets me take your land, or at least take some value of your land without your approval, right? I mean, what I'm still doing affects the value of your land, and what we're saying is, instead of stopping what I'm doing because there is a great deal of value to it, however you want to phrase that, however you want to determine value, but I'm going to keep doing it. Here, take $5 grand, or take 10 grand, or whatever the reduction in the value of your property is. I mean, that's like it's like a taking of your property, but done by a private party, not by the state, which is authorized to do it under the powers of eminent domain and the like.
Yeah, it's like being reimbursed for eminent domain. In a way, it's similar to that. But however, you get to keep your land. You're just being paid for your sufferance on a accordance basis for, you know, over a certain amount of time.
But that seems to run contrary to some of the other law that we've looked at in this area, where in essence your home, your land, and the like that you live in is your castle. Now at least in part, one could use this case to suggest, well, at some point we might start to look at balancing it. Like, I think a good example of that might be the Manchester airport area. Right, okay, listen, I don't want all these planes, I don't want all this noise, I don't want all this traffic, because if you look, the little neighborhood just got virtually swallowed up there that's on the way to the airport. But the fact is the airport, we need more forms of travel. And again, it is one thing if the state or a public entity takes the property by eminent domain. It's another thing to allow a private actor to come in and, through their use, devalue your land and then say, well, you don't get to stop it, you simply will get some form of injunctive relief, and as they say here, it will be some type of servitude on the land, perhaps, and the like. Because the other alternative is, I could even move to the nuisance and still complain about it, right? What do you think of that notion? Because that seems to be, at least in part, what a lot of people do. Not just in the cement, not just in Boomer, but in many situations, and I've had a number of cases where this is so, you had some understanding of the character of the area when you moved in. Now that you're there, you say, I don't really like this. I mean, there's something unfair about that aspect to it as well, right? Fred moves into a rural area, roosters are part of that mix. Not at 2:30 in the morning, I wouldn't think, but they are part of the mix.
Don't you normally do an investigation once you scope the area? But then again, the argument comes back to what season it is, and then if it was the farm, you may have not smelt it in winter. But I mean, I feel as though, as a homeowner, you're going to scope the area, and see if there's any possible.
Do you though? Because see, I've told you the story when we did the pig case. I grew up in the city of Dorchester, which, I mean, my yard was probably the size of these two tables. So.
But I'm sure there's some funny smells in Dorchester, though, too.
Nothing like out here, frankly. No, I mean, seriously. We used to take the kids up to the cows at the top of the hill, and there were there were times where you'd turn that corner, and the smell would actually gag you. The farmer actually told me what it is. It's the smell of rotting corn. And the milk from it, that time he had milk cows there. So the milk and the corn somehow get together, ferment, and I'm not kidding. There were times where you turn that corner and you'd like almost throw up. And then the other occasion was with Farmer Barker's farm, and I didn't know anything about farms. In the spring, they have to fill the fields with manure and stuff so that they can grow that corn that we all love. Yeah, it's fertilizer, all right. But what used to happen is he'd fill a honey wagon at the top of the hill with the cow manure, wet cow manure too, bring it down over the road and into the field. And so when I'd come home at night, I drove that same road, and then in our garage was in under our family room. And so I park under in the park right park, your garage, and I'm sitting there, and in the house in my chair. And, the whole house smells like shit. And I said, what the heck? How did this happen? And it took me a little bit to figure it all out. But it figures out because all that stuff falls all over the road as he's putting it, bringing it down from the hill out to the fields, gets on your tires, the tires come into the garage, and it's obviously, again, something you can get used to. But my guess is someone who was more inclined to complain and the like would have found a lot of this, in fact, a nuisance. And so, but there's something unfair about that, isn't that? I mean, like you said, there must have been smells. There wasn't smells in Dorchester. We had fire engines and police cars, okay? So you get used to the noise. Do you know what I mean? You get used to what it is. And so that just sort of becomes accepted. We were in D.C. one time, slept like a baby, even after having moved up here to North Andover. Larry gets up and says, "Oh my God, I didn't sleep all night, all the damn fire engines and police cars." It's you adapt to the way
I
it
live
is.
right near a firehouse, I'm used to the noise, so.
Well, what about that, right? Same type of thing. You can complain about the firehouse, but the fact is the social utility is such that we need that.
After a while, it becomes white noise to you anyhow. I mean, you get so used to it that you'll sleep right through it.
Right? And so, and I'm not suggesting that an active cement plant isn't probably a lot more intrusive than some of the noises and the occasional smells that we get from farms and all the rest of it, or even the fire trucks that we know we need. But isn't there something slightly unfair about that? You, in essence, have come to the nuisance, and now you want to really hit the jackpot, right? In part, we would imagine your value, what you paid, was affected by where you were located and some of those problems that someone else saw. But the law still allows you to move to enjoin it. That's what they did in Boomer, right? I mean, they were looking at enjoining it, but phasing it in. Go ahead.
Yeah, I think it's interesting. The court seems to be compromising in Boomer because, but I take your point about the unfairness because if everybody was to go to court, that's basically the thing that they said. They were just going to decide that if a private party wants to go to court and they can prove that it's a substantial harm, then they're going to get. So if everybody's going to court, the cement company is going to go out of business. They try to compromise by not going beyond the case in front of them and considering it like a public health problem or something and enjoining the cement company.
But at the end of the day, if the cement plant has to go out of business, it's going to have to go out of business or relocate somewhere else. Right? What they did here is they enjoined them from continuing the discharge of dust particles upon its neighbors' properties unless within 18 months the cement company abates the nuisance. Not unusual at all, especially for something that has value of this sort, to sort of give them a period of time to either come into compliance or shut it down. But the fact is that at the end of the day, they reject the whole notion of this inverse condemnation and say, at the end of the day, you can't just take someone else's property unless they're willing to allow some type of permanent damages. And here, what they've got is a legitimate nuisance, and what we're going to do is phase it in. And if they can't fix this within this period, out they're going to go. Let's take a look at Pate versus City of Martin.
Is there ever a point where a private company, like let's say, you remember Berlin, New Hampshire, when the paper mill Rand, did you ever go up through there? Like, you literally have to hold your breath from one end of town to the other, or you
Want to know that
feel
story?
like you're gonna die.
I
you
get
know?
it. We get out in,
But the whole town
Remember
depends on
Savannah.
it, and once it's shut down, the whole town is like a ghost town.
get off the airplane in Savannah. We've got a meeting we got to get to. Go out to the front, you know, where the cab's at. You take a breath. You say, "Oh my God, the whole place smells horrible."
Sulfur, yeah.
Sulfur. I said, "What the hell is that?" I mean, it really stinks. And it's the same thing with Berlin. And the cab driver and whoever was near the cab driver said, "Son, that's the smell of money.
Yeah.
You accept it because that's where everyone works. And if you want the jobs,
I mean, the existence of the town is literally dependent on that business.
well, this was Savannah,
So when
Georgia.
does
This
it
was a
become
big
like an
town,
issue
and
of
they
almost
felt
eminent
they felt the
domain?
very same way. So what do you do, and what is the chance of going in and saying, you know, shut the paper mill down that employs everyone here?
And all the businesses, that even if they don't work for them, they depend on the employees to buy lunches or clothes and, you know, I mean, everything.
These are the problems with these cases, especially the larger ones, Fred, is precisely what you put your foot on, your hand on here. What do we do? Because Berlin, and there was someplace else just outside of Portland that must have had one too, because when I used to drive up north from Portland, there was a part, about a 10-mile stretch, where it was the horrible smell like that as well. And again, the paper processing plants they really smell.
There's another one in northern New Hampshire, on the western side, I can't think of the town, but they pretty much, like, couldn't fund their police department. The town basically went bankrupt because the paper company went out of business.
Well, so when we sit here and talk about the utility of it, it's not just the social utility. There are lives and people who depend on it. I mean, I can't imagine living near a coal plant, or, I mean, look at the next big thing are all these fracking with the gas, the natural gas, which are creating horrible nuisances and environmental damages in various places, and real health hazards. So, but the question is, well, if we shut it down, if we shut the paper plant down, if we shut the drilling operation down, people are going to be out of work, and the whole town may lose its vitality as a result of it. Well, what do you want to do otherwise? People have to be exposed to then these health hazards, and I mean, it's one thing to say I don't like the smell, because that may not be a winning argument if there's significant economic and social utility to what we've got. Because when we talk about reasonable and substantial, that you have to recognize that gives the court an awful lot of play here, right? Even in determining whether it's a nuisance. And when we're talking about substantial, and so if it smells but it's not harmful, the potential argument is it's not substantial. It's a smell, and we'll get used to it. But this is the problem, because the court has a fair amount of latitude in trying to shape the solution to the problem.
I don't mean to backtrack, but in Boomer, wasn't the injunction granted but then vacated upon the payment of the damages? So they didn't necessarily shut it down, right? I mean, they kept going and they just paid them because they kept operating, correct?
Hold on, you got to go back to it. I think that was what yes, that is in fact what the court says is to grant permanent damages to plaintiffs, which will in fact terminate the litigation. So in essence, what we've done is inverse condemnation. It's the dissent that talks about maybe we should phase in compliance here, give them 18 months, either abate it or be done with it. But this is a situation where in essence, they have granted permanent damages against the land, saying that it can't be remedied beyond shutting the plant down, and because of the need for the use of the plant still,
That they were just going to pay them out X amount of dollars per.
just as you said, either grant the injunction or, and it's their option, pay permanent damages because of their effect on the plaintiff's land. And if it's permanent damages, then that means the people that buy it subsequent to this, they'll be done. There will be no further actions coming and the like. And this is it's somewhat rare, but I have seen it, and you are seeing it. I'll give you another example of not this type of situation, but an attempt to resolve it with this type of solution in advance. I don't know whether you're familiar with where Gillette is in South Boston, but it used to be a large manufacturing facility. It's smaller now, but Gillette is still there in many ways, most of their administrative offices and the like. But a large portion of that area has been, the buildings that Gillette once owned have been converted to housing. What they did within those condominium documents themselves is to create this restriction, or at least this awareness that trucks come and go at 5 a.m. This is a manufacturing facility as well as a residential facility at this point. And when you're buying the property, you are coming in with an understanding that there's a lot of noises, there's a lot of smells, there's a lot of all bunch of things that you might otherwise find offensive. And you are buying subject to all of those things and limiting your rights to proceed later on for any of these issues. And it's right built within the documents themselves as covenants as part of the agreements. The other place we've seen this type of inverse condemnation, and it's either, I think it's in Western New York. I had the article at one point, and it's again, it's an energy issue. These windmills make noise, and you know, we all want alternative energy, but you don't want to be necessarily that close to it. And both from a standpoint of aesthetics, but aesthetics, you're probably going to be losing argument these days, but the noise as well. And so what, I think it's Western New York, where they had both the windmills and the power lines, and people were complaining about the damage that that was causing as a nuisance and the like. And what they did is they allowed this type of remedy, sort of an inverse condemnation, because of the need for the energy and the need to place this type of utility somewhere. And so therefore, they awarded the homeowners permanent damages against the land, filed the judgment against the land, so that anyone who bought subsequent to that was buying with the understanding that these restrictions were in place, and you were likely buying less than what you would if you were buying well away from this type of nuisance.
So their grantees do not get any portion of those damages?
No, none. Theoretically, the market value will reflect those damages, right? But theoretically, if that house was worth 100, since you're taking with notice, if the house was worth 100 somewhere away from this problem, you should be paying 80 because you've got this problem and you're taking with notice of the problem. So it's like, it goes back to a point you made earlier. You better investigate that, and you better have some understanding of that going in, because the market should reflect it. The market price is at that point supposed to reflect it. Any of you have ever been to Winthrop, Mass? We were at Winthrop when I graduated from law school a long time ago. And one of our classmates was having a party there right on Boston Harbor. Oh my God, you couldn't even carry on a conversation.
Air traffic.
You couldn't carry on a regular conversation because the planes were landing very frequently, and it was ridiculous. So I mean, but we need airports, and despite lots of abatement and the like, at the end of the day, you're going to have noise and all sorts of other issues related to that.
Similar thing happened in East Boston. A bunch of families and homes were reimbursed for their windows, and they would put actually new Anderson windows that would actually withstand the vibration of the flights flying over.
Right, and by the way, you sometimes see it along the highways as well with some of these, the walls that they'll put up to try and send the noise up instead of through the neighborhood and the like. So there are other ways, and that's the other thing the court looks at. And let's look at Pate versus City of Martin, which is one of these other ways that the court will try and cure the problem. And again, equity can be creative, and you can be creative about how you go about trying to resolve something. But I think the really good lesson to take from this case, though, is next time you think you have a really bad job, you remember the little guy in the tiny bowl boat here, right, Melanie? That your job can't possibly be that bad, being in a motorboat full of poop, churning it so that it won't smell so bad for other folks.
What's the title of that job?
You want to inquire about it, do you?
I'm looking for sure.
Yeah.
It was
You know?
advertised as sanitation engineer.
So let's talk about this, because these sewage lagoons are issues. They're actually issues in my town as well. Because a couple weeks a year, when it's hot and the wind is blowing right, honest to God, there's a main street, it is one of the main streets in town, that as I ride up it, as Fiona tries to hit me with her SUV on my bike, you really can smell it. Now, it's not that often, and it's not that many times a year, but my guess is if you lived closer to it, it would be pretty bad to have to be smelling that to that extent. But again, we've got to treat this stuff, and there are various ways to do it. You might like to put a $15 million dome on top of the lagoon if you live next door, but if you live a little further away, you might not like your tax dollars to have to be spent on something like that. So if you look at it, and it talks about a temporary nuisance or a permanent nuisance, and so, and there's two ramifications to that. It's both how long do you have to bring the claim, and what are the potential remedies depending on whether something is temporary or permanent. So the chancellor in this case found that the lagoon was permanent and awarded damages. So first of all, what makes something permanent versus temporary in regards to the reference as a nuisance?
Permanent is not abatable by labor or expenditure of money.
Permanent, not abatable by labor or expenditure of money. Temporary
Is.
right? Pretty straightforward. One can be fixed, one can't, or at least they say it as can't. Can't is obviously, in this case, there's an argument about that. What about statute of limitations when something's temporary versus permanent on a nuisance? Do you think that matters as well? How do you think it matters?
I mean, 'cause for tort actions, it's 3 years in the state of Massachusetts.
3 years from when?
From the date of your report of.
Date of what? 3 years of what? Injury? Is that what you said?
The date of report of injury.
So,
No, the date that you.
Discovery.
Or reasonably should have.
Or reasonably.
they discovered or reasonably should have.
Like, because
What?
maybe being injured and not know your land, your property might be, you know, like in the case of the septic system underneath the other person's
Right.
property.
You couldn't have discovered it earlier.
Right.
Yeah,
But
but
you
what
discovered
about-
it, so it's 3 years from then. Well, what, is it 3 years from then? That's what I'm worried about. I'm not worried about it, I just want to inquire about it. Permanent says it can't be fixed. That's the nuisance, and I would think 3 years would run from, so, suppose it runs from when you discover it, as you point out. For permanent, I can understand that, I think, better, but a temporary is one that can be remedied, right? So why isn't a temporary one, in essence, since it can be fixed, every day it's not fixed, begins the statute of limitations again? Right?
Yeah. I would agree with
Permanent's not fixable, at least this is what it says.
No, you're gonna be in contempt if you don't fix it.
Oh,
Not for that order.
no, suppose someone just doesn't bring the suit. This order's been here forever.
So every day
It's-
that.
Every day is a new day of violation, isn't it? Well, because each day is a new injury, isn't it? If I hit Fiona today, 3 years from today, right? I hit Fiona tomorrow, 3 years from tomorrow, right? I hit Fiona Saturday, 3 years from Saturday. Every new day is a new violation. Isn't that the theory behind a temporary nuisance as well? You may be guilty of laches, you may be guilty of other things, but in a temporary nuisance, since the injury is fixable, isn't every new day of the injury a new violation? And the answer is yes. Okay? And so that's another distinction between temporary and permanent, is statute of limitations, while you're only going to recover on a temporary nuisance for 3 years from the time you file suit. So if you have greater damages in years 4, 5, 6 prior to filing suit, you're out. But you can still bring it. There's an argument that on a permanent nuisance, if you don't bring it within 3 years, you don't have any remedy whatsoever because it's untimely. Go ahead.
Yeah, it says here, where the nuisance is temporary, damages to property affected by the nuisance are recurrent and may be recovered from time to time until the nuisance is abated.
Right? Because it's curable.
Yeah.
A temporary is curable. Go ahead, Laura.
I'm just kind of confused about permanent nuisance. How can something not be cured by, like, an amount of money? Is it as, I mean, are you saying a specific amount? I would think that someone could make the argument that anything can be cured with an amount of money.
Well, and I think that's the better argument here, isn't it? I mean, depending on how much money, can't we still virtually, not to be overly cynical as lawyers, but what isn't fixable with a significant, with an unlimited amount of money? Because here, well, there must be a number we can fix this. For many years in our town, what they said is, yeah, we can fix that problem. What it would mean is putting cement enclosures over all of these lagoons, and we could be done, but the cost is $15 million. Right? If you think about enclosing it, that has to stop the stink in some respects, because these are, in many areas they are, you know, near these large industrial farms, that they're open sewerage lagoons there for pigs and all of that stuff. So again, that waste smells as well. But Laura's point, well, does this mean there's no number in the world, or the number is just outrageously expensive, such that therefore we're going to call it permanent? Because, I mean, this is fixable at some point with money. There must be some amount of money that we could cover these. But here, at least initially, he says, no, it's permanent, we're going to award damages, and if it is permanent, by the way, we're done. Right? If you work this through, if we award permanent damages, okay, Fiona, the value of your house, you lost $5,000. Here's your $5,000. File it as, in essence, a restriction against the land. The next time the neighbor comes in, you're out of luck. It's a one-time award of damages. It's probably cheaper than building the cure, and that's not quite what permanent means, because as Laura said and you guys read, permanent means there's no amount of money that can fix it. Go ahead.
No, I was just having a tough time with permanent versus temporary nuisance, because the expenditure of labor or money could essentially wipe out a permanent nuisance, no? I mean, that's
the argument. That's the argument about.
Well, the defense is maybe economic waste, though, you know? Like if it
Well,
costs more, you know, than your business is
Yeah,
worth,
but they don't
fix the
they don't
problem.
define it. It's just it says expenditure of labor or money. It doesn't define how much money or labor.
Well, but again, that's why I like this case. Think about the solution here, because we can say it doesn't involve any of that analysis, but to some extent it is. It's affecting the court's thinking. We stick a guy in a motorboat, we pay him God knows what a year, and we don't really have a problem. That's a lot less than saying you spend $15 million this year because we think that that'll fix it. And so I agree with you as to what the law is saying. It can't be fixed by the expenditure of labor or money. for what can be. There's always a number that should fix virtually anything. Virtually anything. They are, I'm not sure they're saying there's no amount. What they're saying is it doesn't make sense to spend that amount. No reasonable amount. Go ahead.
What would happen with a temporary nuisance if you sent notice, if the other side got notice? Do you think that would start to toll the statute of limitations?
No, no, not on a temporary, because again, it could be a laches argument that you've delayed asserting your rights, so therefore there's prejudice that follows from it. But every day on a temporary trespass is a new violation. So I could tell you, stop it, and then I get tied up and I do God knows what, but you're still putting the water on my land or whatever it is that's affecting my use and enjoyment, whatever it is. And I can still come back in another year from now or 3 years from now and say, stop it. If it is abatable, every new day constitutes a new violation. So you don't lose the ability to bring it. What you lose is the ability to recover damages for the period outside the statute of limitations. You understand that? So that
For the first injury.
yeah, for the years 4, 5, and 6 are gone, but you can still recover for the last 3. By the way, not to minimize that, because in some cases that's not an insignificant amount, depending on what you're saying the damages are. So there are limitations. What it means is you are not completely barred from bringing that action, as long as, at least for damages within the 3 years, if it's a temporary nuisance. Okay? So looking at this, what happened here is they filed it, they wanted damage, they sought abatement of the nuisance and damages, which, by the way, that's generally the way this works as well. I want an injunction against future harm, but I want damages for the injury done to me in the past. That's the way we remedy it. If your use and enjoyment has been affected, that converts to damages for the past wrong, and the future wrong is remedied, hopefully by way of an injunction, so you're not suffering future damage. What happened here is that they found that the sewage lagoon was a permanent nuisance and awarded them a straight $10,000 and said an injunction would be too harsh a remedy and denied it. They then went on appeal, and what happened there is the court determined that the nuisance was in fact temporary, not permanent, said that the damages argument was too speculative, and let's see, what did they do? Let's see. Called the nuisance temporary, reversed the award, and dismissed their action for failure to prove damages for impairment of the use and enjoyment. So they ended up getting nothing on appeal. And so then we go back to the Supreme Court to take a look at the case. What they found is that the little guy in the motorboat could churn the scum from the pond, and by doing that, it significantly diminished the odors to those in the surrounding area. And then we've got a definition here. A nuisance has been defined as anything which annoys or disturbs the free use of one's property, or which renders its ordinary use or physical occupation uncomfortable. That's a pretty broad definition. I think certainly Alice's music falls within that definition. And then it goes on to say, that by citing the case, it says, a nuisance extends to everything that now endangers life or health, gives offense to the senses, violates the laws of decency, or obstructs the reasonable and comfortable use of the property. I mean, this all seems to fit that pretty well, and I can tell you from our town, I think the people that lived on Sutton Street when this was even more acute would definitely say it. I could smell it from a block away, driving a vehicle. So my guess is having to be there would have been difficult at the time. And it says here that they found it's a nuisance in fact. Number 1 and 2, a nuisance which can be corrected by the expenditure of labor or money is temporary. And if it's temporary, you can get your damages from time to time. The measure of such damages is the injury of the value of the use and enjoyment of the property, which may be measured by a large extent by rental value of the property and the extent the rental value is diminished. Let me ask you a little bit about proving damages. So suppose you did live next to the sewage treatment plant, close enough to it that you could smell it. So what are you saying? Your fair market value, the rental value is less than what it should have been? But how do you, so how do you plan to prove that?
Well, you
I'm
take,
paying $800 a month, but what?
but you take the square footage of a place that's similar in the area that's maybe away from the smell, and you compare it to that, and you deduct the price that way.
But see, that's gonna give us a different figure, I'm afraid, no? Because suppose you're the homeowner, and you're living in the home. You don't really have a rental market because you're not renting it, but you're saying your personal use has been diminished. But how do I prove what that value of diminishment is? Because I hear your argument is that, well, I can't rent it out, and if this, or if I'm the landlord, I can rent it out, but I can only get 6 because of this problem. If it was on 4 blocks away where you can't smell it, they're getting 1,000. My loss, $400 a month. If I'm the landlord, I'm with you. I don't know how the homeowner shows the damage though. Go ahead.
Maybe times when he cannot use the house, when the stench is really bad.
So what, okay, suppose we give you, we'll say it's a month a year. It's an outlet. But when you say not use the house, are you not using the house? I mean,
Maybe when there's certain times of the day when the sun is really hot, the sewer smells really bad, so you have to go to get a hotel, you gotta eat outside.
but do you really? I mean, is that likely for most people that they're gonna go to a hotel, or they're just gonna put up with it? Laura, you're not gonna go, go ahead.
Maybe the money it would take to buy things in order to fix the problem, like air purifiers for your house and stuff like that.
So I'll give you some air fresheners and air purifiers. And by the way, in East Boston and the like, there were a lot of abatement measures like that. The extra windows, in some cases building the walls even thicker, roofs. Massport and the federal government tried a lot of different things along those lines because the nuisance wasn't going to go away. Logan Airport wasn't going to close down for anyone. And so what they did is try a lot of those alternative ideas to see if it could make it more livable. Go ahead.
I was just gonna say that it seems like either way the homeowners are gonna lose out because, I'm from Tennessee, the city here is like, it's super hot all year round, so, you know, so there's gonna be no break. I would imagine it's probably in a poverty-stricken area where some of these homes probably aren't worth $18,000 with the land included. And so, like, at some point, the court, I would imagine, is not gonna give them a windfall on property that's, you know, worth $20,000 at best. So, seems like the people are pretty much screwed because of the social utility of needing a sewer. So, what power does the court have to say you have like some particular time frame and make it reasonable? Otherwise, I could see the city just saying, hey, it's worth it just to like pay up to the amount the property's worth, because there's only like 6 homes here in this rural place, and they're dilapidated poverty shacks, basically. So, and then these people don't have the means to, you know, put in air conditioning, much less move or go stay in a hotel when, you know, when it's really bad. So at what point does a temporary nuisance become permanent because the time period went by, or the city just decides, you know, whatever, we're not gonna fix it because it costs less to pay the homeowner?
Well, I think what
What's the court do with it?
what they do is what you guys have been talking about, I think, is trying to balance it, recognizing that we have a definition of temporary and permanent here, but we also have reality that that sewage treatment plant's not going to be shut down. The airport isn't going to be shut down, and a lot of these places aren't. and they're gonna work, and neither is the cement plant, as we saw. And the fact is, a lot of these things are in areas where it raises a real issue of the expression we give to it is economic justice, is the question about, where are these chemical plants put? Where are these hazards put? They're not put next to Ted Kennedy's house in Hyannisport.
Same with the prisons.
Same thing with prisons.
Federal prison, I mean, employs a lot of people valuable to certain communities, but they're not putting it,
What's fun, you raised the issue of Berlin. That was the
Yeah.
big deal up there, was they wanted the damn prison open.
Right.
And they fought for a couple of years to get the federal funding to open it because it was gonna mean jobs. But the same type of argument, no one wants it right next to them. It's gotta be somewhere, and the fact is, it's gonna affect the value and the manner in which you live if you're living right next to it. So what are we gonna do for these people? Or are they just gonna have to rely on the tiny bowl guy to get out in his little boat and try and take care of it as best he could? Go ahead. Gotta speak up, Fiona.
Wouldn't it make more sense in terms of a public policy argument that these companies try to move in areas where there's like no residential areas, period, so they don't have to encounter such issues?
Well, where do you put it?
Like maybe have government have some areas just zoned specifically for businesses, non-residential, period.
Well, yeah, I mean, zoning would be one way to resolve it. I think in Boston, what we got done is put it way out at Deer Island where it was treated, and then even moved the outflow pipe as a result of fixing Boston Harbor 10 miles offshore, so you had less problems. But yeah, planning would be one way to solve it. The problem is all these cities and the like grew up around these.
Well, yeah, the expansion, it's no different than Andover, right?
Right.
With the pig farms, I mean, it was a farming area, and then developments start coming in. I mean, they moved to the nuisance, but eventually the pig farmer gets shut down.
Well, that's the Del Webb case, which I imagine you read. It's out in Arizona. Del Webb decides to build next to the problem, and then wants to complain and say, listen, I've got this beautiful residential development. And as Fred points out, that's the story around here at numerous farms. This had once been a significant agricultural area, and so there are a lot of farms, but now there are a lot of big homes, and the big homes don't want to put up with their messy and smelly farm neighbors. And it's where the rubber hits the road, unfortunately. There's a significant piece of litigation, and it's been going on for years over in Boxford. The guy is a very well-known and by all accounts, terrific family law lawyer. He lives next to, not just off 133, next to, what the hell's the farm there? Do you know which one is it? I can see the sign.
Smollett?
Huh?
Smollett?
No, not Smollett. Smollett has its own issues, but it's not as bad. This guy has been in litigation with them for ages. Oh, it's across from Main Tree Kennel. No one's seen it? Huh?
Not man. I know what you're talking about.
Not Mans. I forget the name of it. Huge litigation because what that complaint is, because there's some protection for farms. Remember, if you remember the case that some of you had first year, there's some protection for farms from nuisance. But what his argument is this is not agricultural anymore, just like Smollett. This is agritainment. This is, go pick a pumpkin that was grown somewhere else. We're just going to throw them all over the ground for you to come pick them up, take a hay ride, come for an ice cream. I mean, Smollett in our town is a major entertainment facility as much, and probably more so than a farm, frankly. And so, if you were the neighbors, to some extent, that's a nuisance. What the complaint is at the other farm, and I can't for the life of me remember the name of it.
Ice cream starts with an I or something.
No, they don't have ice cream there.
I know what you're talking about, because Smollett takes their corn, and so
Oh, yeah? I'll find you, but anyway, over the period of time, what he's saying is, this is not agricultural. This is a nuisance. You've got people cutting Christmas trees, and you're selling all these baked goods and everything else. I don't want all this traffic here. I don't want people using my driveway to turn around. I don't want any of this, and he's fought significantly to cut back their retail operations because of the nuisance it's created. This problem is everywhere around Essex County, simply because of the changing nature of it.
To me, that sounds like a nuisance that could be easily solved with money if you just, you know, send some money to that gentleman's way, no?
This is, it's become intensely personal. I think the lawyer's name is Jerry Nissenbaum. He's an excellent family law lawyer, very well regarded. But he lives right next door to it. And to me, it looks, it looks kind of nice. You could walk over for coffee and stuff in the morning. But there's a fair amount of traffic that comes and with all of that as well. Nothing like Smolak's, by the way. If you lived on those streets that surround there, nothing like that. But he doesn't want any of it, and it's caused a lot of significant litigation with both the town and the farm owner to try to limit their nuisance. So you're going to have to show, it says here, the value by which the property has been diminished if you want to recover damages. And again, if you go out to the hotel, you've got some bills and the like. But the problem here is, how do you value what it's like to be able to keep the windows open on a summer night, to have food on your deck, to be able to just have the kids play in the yards without gagging. And so, yeah, we're going to have to try and put in some type of rental value loss and the like, but that's going to be easier said than done as you start to think about it. You got one more to do, and this is Myers versus Arnold. And again, this is permanent versus temporary and the like. And I think this is another interesting case with respect to the problem that they've got here. But they wanted, at least allegedly, they want a little bit of fill, and instead of a little bit of fill, and they've got a property of about 25 acres. Instead, they get concrete reinforcing rods and concrete, 8 feet high, an area by 50 by 150 feet. So 7,500 square feet. 8 feet high. When she had asked for a load, she ended up getting this from a construction road project, and she says this is where she intended to build the home. Lucky for her, because the value of the damages is a lot higher if it's to her home as opposed to simply the value of an acre. What was the value of an acre of this land? $750, right? Plaintiff's property was valued at $750 per acre. The cost to remove the concrete and truck it away is $19,000 or $18,200. She says she never wanted it there in the first place, so she didn't want this much there. At the close of the first day of trial, the defendant moved for a directed verdict. What's a directed verdict? Sounds familiar. What's a directed verdict? Did it motions? So what's the answer? Which motions? Did you do that in? Oh, okay. She threw you under the bus. Said you should remember it because you're in that. She can't, but you should. Go ahead.
I've got it in my judicial handbook here.
What do you got? Let me see.
Directed verdict. In civil jury trials, if after all the plaintiff's evidence has been presented, there is insufficient evidence to support the plaintiff's claim, the judge may grant the defendant's motion to take the verdict out of the hands of the jury and enter a judgment, a direct verdict against the plaintiff.
What are you reading from? Let me see the cover.
The Handbook of Legal Terms for Judicial Branch Personnel.
Where'd you get that?
I acquired it.
No, who's the publisher? That would be nice to know.
Commonwealth of Massachusetts Administrative Office of the Trial Court, Boston, second edition, fall 2007.
Very nice.
And Would you like me to read the directed verdict in criminal, or?
No. Tell me what the motion number is. Come on, some of you know this. Yeah. Motion for directed verdict, motion for judgment notwithstanding the verdict, motion for judgment as a matter of law. Rules have numbers, right?
Oh, 50?
50. 50. So if you had to explain that rule to me without looking at the book, could you? Rule 50, directed verdict, says no reasonable jury on the basis of this evidence could find for the other side. Right? It's a motion that tests the evidence introduced at trial. And what they're saying in this case is that the plaintiff offered insufficient evidence as to the value of her damages. Okay, she's got an argument that this shouldn't be there. But the fact is, she's got insufficient evidence that her damages are 18.2, especially when we're looking at an acre of her land at of 750. So if this was a permanent trespass, what would her damages be? How much? Come on, this is not complicated. It's a diminution in market value, right, before and after. So therefore, it would be 750. If it's a temporary nuisance, she's entitled to have the property repaired, correct?
To its property to its original condition.
And what's the value of that? 18.2. So she wants it to be temporary, and she doesn't want it to be just commercial in nature, because otherwise the argument might well be, listen, if this is a commercial enterprise, the value of her damages is 750. She had an acre of land, I took her acre of land, here's your 750, see you later. That's what she's saying, is she needs it back in the original condition, because out of the 25 acres she has, that's where the new house was going. Right. No, right, because I'm going to take that 25 and I'm going to go find somewhere else, and I'll cover that with dirt or do something. I mean, the reality of this ending up the way she says, I don't see it. Doesn't matter. What the case is here for you is to make this distinction between the value of damages between temporary and permanent. And temporary and permanent really just turns on whether we can fix it or not. You guys have already determined the problem in the other case with when we say fix it or not. Geez, that likely could have been fixed, even if it's outrageous. And as Fred points out, then we better at least add reasonable, whether it can be fixed reasonably under the circumstances. And so under these circumstances, as much as we may disagree, she should get the value on the temporary. And the temporary in this case is she gets $18,000 to try and put this back in the position, put her back in the position she was, but for this wrong done to her. I need to ask you to fill out these evaluation forms for the class, and I need someone to pick them up and bring them to the registrar's office. Someone, Fiona, pick them up and bring them to. Rule 13 is counterclaims. While you're passing those out, let's talk about them. Counterclaims are either permissive or compulsory. A compulsory counterclaim arises from the same set of facts or circumstances as the claim that was asserted initially in the plaintiff's complaint. A compulsory counterclaim must be brought in response to the initial claim, or it's lost, because it arises from the same set of facts or circumstances as the principal claim. A permissive counterclaim doesn't arise from the same set of facts or circumstances as the principal claim, and therefore it doesn't need to be brought in response to the principal claim. And if it isn't brought, it isn't waived because you can bring it later. But if it is brought, it generally needs a separate basis for subject matter jurisdiction. The point to remember, the big point to remember, is a compulsory counterclaim, if you don't bring it, you've waived your right to assert that claim later on. Therefore, you must bring your compulsory counterclaims at the time the claim is asserted. And they're compulsory if they arise out of the same set of facts or circumstances as the principal claim. Questions? Also, remember, from a strategic standpoint, the best defense is a good offense. So if you do have counterclaims, First of all, even if you chose not to bring them, that's a discussion that has to take place with your client, and make sure there's an informed decision that's being made. You don't, on your own, you just don't have a right to waive your client's claims like that. So that's a serious discussion before you choose to forego it, because you don't want to get bitten later on. And if it's a permissive counterclaim, sometimes you still may choose to bring it simply because to help use to offset that principal claim. Again, I think it's better to be seen as a wronged party than just simply falling back on your heels having to defend what the other side has. So a lot of times people will assert counterclaims if they can within Rule 11. Questions? Okay, fill out those forms if you would, please, and then give them to Fiona so she can give them to the registrar's office, please. Thank you.